So the shutdown is upon us. What should you do if you've got an employment law case, particularly if you have filed with the EEOC or another government agency? Hi, I'm Tom Spiggle with the Spiggle Law Firm. We help people who've been fired or afraid that they might be. So we are at our firm already getting notices this morning from the EEOC that the offices are shut down. This is not surprising, but it does mean if you've, as in our case, if you've got mediations that were supposed to happen, those will no longer happen. The EEOC's doors are shut. Now, you can still file with the EEOC if you've got a charge to file, and you should, because your statute of limitations will still lapse during the government shutdown if you need to file with the EEOC because you've got a deadline coming up. So if you've got a case before the EEOC, or if you are thinking about bringing a case, as I posted in my last video, well, let me say, we'll see how long this shutdown lasts. Hopefully it's not lengthy, maybe a week, maybe two, maybe less, in which case, yeah, obviously the EEOC will open back up. It'll get back to business as usual. If it goes on much longer than that, then it becomes a little bit of a problem if you've got a case there, or even if you're going to bring one, because while the government is shut, as I mentioned, they're still accepting charges. So they're going to open up with a stack of new cases on their collective desks, and they've got to work through those. So like a train that are backing up on the tracks, everything's going to move more slowly. Now, they will get this resolved. We've been through this before, but it doesn't mean it's going to slow down your case. And your employer likes that. And they want the EEOC moving. They are fine to let this lie fallow because time is on their side. So as I posted my last video, talk with your attorney, or if you're working on your own, look for a state law claim or another federal claim that you can bring that doesn't require what we call administrative exhaustion, which is essentially filing at the EEOC or another agency. So a Fair Labor Standards Act claim, a Section 1981 claim on race and national origin. If you've got a state or a local law that you can proceed under, anti-discrimination laws, then you should look at bringing those, because you want to keep your heat on your employer. If you don't have those, then you're just going to have to wait it out and know that your case is going to get slowed down a bit. It'll eventually get turned to by the EEOC, but it means that your employer's probably not going to be in any rush to settle. Doesn't mean that they won't, but now they don't have the heat on them. So fingers crossed. Let's hope that they reopen the government soon. Stay tuned.